Hey there, and welcome to week one of CRIM 300. This week, we're going to kind of discuss an overview of the sources and historical perspective of our American criminal justice system. And I say our American criminal justice system not only because that's the subject of this class, but because our American criminal justice system has sources that aren't necessarily originally developed here. When we declared independence from England in the 1700s, the idea that we just decided, oh, we don't want to be a part of you anymore, and we're just going to be our own country, is a very common thought. And in general, that's exactly what happened. But we declared independence, and then we also only knew how to be part of England. We didn't want to be a part of them, but all our historical context, all our experiences, and I say our as in our historical population, our founding fathers. The only thing we knew at that time was how to be British, how to follow English common law. And as much as we didn't want to necessarily adhere to all the rules that are being applied to the American colonies, we didn't have a lot of lived experience outside of being a British colony. So we ended up adopting a lot of policies and procedures from British common law, English common law, Old English common law. And so when we talk about our general source of the criminal justice system, our historical perspective, one thing to keep in mind is that it does have that Old English common law, those roots. But when we talk about modern applications of the law, we really have to narrow down where is it that we get our laws from currently. In general, something can't be against law unless it's written down someplace. So we'll talk about two primary sources of of our legal statutes and our legal system as it applies to modern times. And the first one I want to talk about is codified law, legislative law. The fact that legislators have to write down, they have to enact legislation and make something a law in order for it to be illegal. Or in some instances, they have to make a law saying that you either can't do something or you must do something. Those are kind of the two ways that we classify codified legislative law. And the other one is case law. For instance, codified law would say you can't drive faster than 65 miles an hour on the highway. If there's a sign that says you can't drive 65 miles an hour on the highway, most likely there's some sort of codified Kansas uh, traffic code that says you can't do that. Or there's a law on the books written somewhere that says you have to pay income tax. If you don't, then you're in violation of that codified law. But where is it written that says that in certain circumstances, law enforcement officers have to advise someone of their Miranda rights? Where is that codified law? Where's the Kansas Penal Code, the California Penal Code, or the federal code that says that has to happen? You're going to be hard pressed to find that because it isn't necessarily a codified law. In that case, it's a case law. It's a precedent was set in the case of the example I used, the Miranda case in the 1960s, Miranda v. Arizona. That case was decided by the Supreme Court, and they now made that American law. So it's not necessarily a codified Kansas statute or Texas statute that says there has to be a Miranda advisement. Case law says it. So those are going to be our two major sources of modern laws: codified law and case law. But how do we decide what's illegal? There's there's two schools of thought. The idea that on one hand, folks will adhere to the ideology that most of us kind of have the same values, the same norms. We live our lives the same way, and so we kind of already know what's right and what's wrong in our community. And keep in mind that community could be anything. Community could be the 30 of us in this classroom. A community could be the community of the University of Kansas, or a community of all of Lawrence, a community of all of Kansas, or the community of the United States. There is no limit to the size of a community or a society. So as that society grows, and we get more and more people in that society, in that community, making the decisions of what's right and what's wrong, you're going to get a lot more diversity. You're going to get a lot more conflict in what's right and what's wrong. When you only have your family, if we look at the society, the mini society of your family, for the most part, two parents and the children can kind of come up with their own version of what's right and what's wrong, and always come to an agreement. But if we ask the 350 million people in the United States if something is right or something is wrong, you're going to get a lot of different opinions. And those are the two schools of thought when it comes to how we make things, or what we make right and what we make wrong, what we make illegal and what we make legal. The consensus model and the conflict model. The consensus model says, yeah, we're all the same community. We can figure it out. The conflict model says no, we have a lot of people in this group, whichever group it is. We use a lot of examples, and we just can't come to a consensus. We're really in conflict of what should be right and what should be wrong. And then, since we don't have a consensus, who wins? Who's gonna be the decider? Who gets that final vote? And depending on where you stand in that final vote, if you're the victor or the loser of the debate, of the conflict, you may find it fortunate or unfortunate, but in general, those with the most power are going to be those who decide what's legal and what's not legal, regardless of what the rest of the community may want. And in our society, oftentimes power and money go hand in hand. So those with money oftentimes are the final arbitrator of what is right and what is wrong, what is legal and what is not legal in the conflict model. In the consensus model, it doesn't matter. We all came to an agreement. But in that conflict model, oftentimes those with the money get the final say. And like I said, depending on where you fall in that final decision, you may think that that's right or wrong. You may think that's fair or unfair. But that's unfortunately the modern system that we live in. I mean, let me give you an example. When it comes to uh, deciding what's right and what's wrong, what's more legal, what's less legal. Look at the West Coast, in the Wild West, in the days of the Wild West. Even and as the Wild West progressed and into through history, we had our modern legal system. Uh, Oftentimes in the West Coast, California being one of those examples, we look at guns and knives, the legality of guns and knives. If you look at the penal code in California in general, possession of an illegal knife a lot of times is a felony. Possession of an illegal gun, or concealed weapon, or carrying a loaded weapon in public, those violations of those laws are misdemeanors. So carrying an unlawful knife, a dirk or a dagger, unlawfully is a felony. Carrying a concealed weapon or a loaded weapon in public, being a firearm, a gun, is a misdemeanor. So why are knife crimes felonies and gun crimes misdemeanors? You would think that guns are more dangerous than knives. We look at that conflict model. We look at the Wild West days when those laws were originally being written. Some have theorized that in those Wild West days, those with money could afford guns, and the poorer folks, the less affluent folks, couldn't afford guns. They carried knives. And who is it that makes our laws in society? Who are our legislators? How many less affluent, how many poor folks do you see in our legislature? Not many. Money and power oftentimes go hand in hand. And so even back then, those who are making the laws, it's theorized, said, well, we can afford guns, so we'll make gun crimes less illegal than knife crimes, because those poor folks, those are the real dangerous ones. That's one of the theories when it comes to the application of the conflict model. In that theory, those with money, those with power, came out on top, because any violations of the guns that they could afford, they were just misdemeanors. But those poor folks that carried illegal knives, they were felons. Another example of the conflict model in modern times is the marijuana cannabis legalization debate. Years ago, there was no debate at all. There was a consensus that cannabis, marijuana was wrong and it was illegal. And then with the growth of the population, with more diversity, and there was a changing desire to legalize cannabis. And today, the debate is is starting to the pendulum is starting to swing in the other direction, where you're getting more and more folks who are in favor of the legalization of cannabis, at the very least when it comes to medicinal purposes, and in many jurisdictions when it comes to recreational use. So at some points, there is a winner and a loser when there is a disagreement on what should be right and what should be wrong, and what should be legal and what should be illegal. Uh, there's the legal terms that we use when it comes to uh, whether or not something everybody agrees that something should be illegal, and when they don't, we use a couple of Latin terms. We say mala prohibita and mala in se. Those are the two Latin terms we say. When we say mala in se, when a law is a mala in se law, that is just, you just know that action is wrong in your heart, in your soul. You know that is a wrong action. Nobody has to tell you. Nobody has to teach you that a mala in se behavior or mala in se crime is wrong. Murder is one of the biggest examples we use in class. Murder, robbery, battery, harming somebody else. All of those, nobody has to teach you that that is wrong. You already know. You don't have to take a criminal justice class to know that robbing Casey's is wrong. That's a mala in se law. But what if I were to ask you, is gambling wrong? Is prostitution wrong? Is using marijuana wrong? Almost all of those are going to be responded to differently by different segments of the population, and oftentimes their answer is going to be, it depends. If you have to say it depends, like on the jurisdiction, is gambling wrong? Well, in Vegas, it's legal, but it's not legal in many other cities. Is prostitution? Prostitution is legal in some countries, and it's legal in some counties of Nevada, but it's not legal in Johnson County. So if the answer is, is it illegal? And the answer is, it depends, or it depends on where we're talking, then that's probably a mala prohibita law. It just depends on the culture, the community, that segment of the society to decide whether that's going to be right or that's going to be wrong. Speed limits could be a mala prohibita law. Uh, it just depends on where you're doing it. You have to be told whether or not going 55 miles an hour is right or wrong, because it depends on where you're doing it. So those are two Latin terms to remember when it comes to knowing whether or not society has agreed upon or not agreed upon whether or not something should be legal or not legal. And another segment of deciding whether or not something is illegal is we have to have an idea of what does it take for something to be illegal? Like, what are the literal ingredients of a crime? Those two ingredients, we're going to use another Latin term, and then we'll define those. Those Latin terms are mens rea and actus reus. Mens rea and actus reus. And those come out to, loosely translated, mens rea comes to be guilty mind. And then actus reus comes out, loosely translated from Latin, to be a guilty act. So a guilty mind and a guilty act. So we need to have an intent and a behavior. An intent to do something wrong, and we have to actually do that wrong thing. For instance, if you're walking down the sidewalk and you trip over a crack, and as you're tripping, you fall and you land on someone, should that be illegal? Is that a battery? Is that a crime? No, you didn't mean to fall on that person. You didn't mean to batter them. There's no intent there. Yeah, you had a behavior. You did fall into somebody, but you didn't have a convergence of mens rea and actus reus together to make sure that we had a crime. You just had the actus reus. So if we don't have the mens rea with the actus reus, we don't have the intent with the behavior, we don't have a crime in general. We're going to talk about in a second how sometimes there's some exceptions to that. If you pick up your laptop after class and you get home and realized, oh, shoot, I picked up the wrong laptop. I've got somebody else's laptop. Did you steal that laptop? No, as long as you didn't have the intent to take their possession, you did take it, but you didn't commit a crime in general. And then conversely, let's say, for example, you don't like the grade you're getting in this class, and you have decided you're gonna punch Dr. Bell in the face because you just don't like the grade I'm giving you. And you tell all your classmates, I'm gonna punch Dr. Bell in the face. And so you've declared it. You have every intent to do it. And then you just never do it. Have you committed a crime? You never threatened me. You just said you just planned on doing it. In general, you're going to have a hard time proving that that's a crime because you had all the intent in the world, you had all the mens rea in the world, but you didn't have any of the actus reus. You didn't actually do the crime. So unless we have that convergence of actus reus, the behavior, the guilty act, and mens rea, the guilty mind, the intent, unless those two converge, we don't have a crime. And the exception to that, because there's always got to be an exception, the exception to that is going to be something we call strict liability crimes. So keep in mind that there are a segment of our codified laws in the United States that don't need both of those aspects. They don't need the mens rea. They don't need the intent. As long as you do the action, you're bought and paid for. That's a crime. Some examples of those strict liability crimes are going to be things like unlawful sex, is what some jurisdictions call it. Other jurisdictions call it statutory rape, the underage sex. That's an example. You don't have you can not know all you want that somebody is underage, and just the mere act of engaging in that behavior is still going to make the offender criminally liable for that. Now, they absolutely have a defense for that criminal liability, but their criminal liability still exists. Another example is, say, selling alcohol to minors. You can not mean to do it. You could think somebody is over 21, and if you serve a minor and you say, "Well, I didn't mean to sell it to a minor. They just looked older." The mere fact that offense occurred, there doesn't need to be an mens rea. There doesn't need to be an intent, as long as the actus reus occurs. And then the last example is a lot of possession crimes when it comes to the possession of narcotics. Um, Having drugs in one's car and then getting pulled over and those drugs are found. The mere possession of those drugs, it falls under a strict liability crime in many jurisdictions, and you could not know they were in there all you want, but you're still criminally liable for those. Again, absolutely defendable, but still criminally liable.